All right, so I'm getting a lot of questions about how and why are employment contracts and these restrictive covenants as important as they are. And I think it's best answered with unfortunately true story. So there was this company that came to me kind of after the fact, didn't represent them to this process. They had built an entire wing for basically conventions. Okay, so they hired on at a very high pay these two employees that were really to head up this whole wing, this whole department of their company for conventions. Importantly, they did have an employment contract there, but it was very outdated, and I don't believe it was done by an attorney. If it was, then it was done too many years before. So they hired them. They started them to move forward on this this wing, this new vertical in their business, and they spent a lot of money on it, and they finally got it up and running. It was about $1 million or even $2 million a year on some years, doing all these conventions around the globe. Then about 10 years in, when these were really starting to move forward and go well, these two employees, both of them demanded about 100% raise. Obviously that was not in the cards for cash flow reasons and a million other reasons. So when they were denied that raise, they both left, and they were able to completely compete with them, and they basically stole that whole wing of the company, and they set it up. They wrote to and solicited all of the vendors, certainly all of the customers. They even stole a lot of the, certainly the trade secrets, but also some of the materials used at these conventions and seminars. I mean, it was a real tragedy. In their employment contract that they did have, they had what's called an arbitration clause, which I'm sure you've heard about. This made it so that any litigation had to go to this arbiter. Now, unfortunately, again, the arbiter had zero legal training, zero legal education or experience, but was put in this position to be a judge. The way that it works with arbitration clauses typically is that whatever the arbiter decides, no matter how egregious, pretty much is what you get. You can't really appeal an arbitration decision like you could a regular court decision. So they went to court over it to try to stop them from competing against them, from stealing their trade secrets, from stealing their client lists, from soliciting employees at their firm and all of their speakers and everything. And the arbiter, for whatever reason, unbeknownst to me or other lawyers that were looking at the case, stepped outside of the law basically and just held in the favor of the competitors who were very much in bad faith. It's a bit of a tragedy. It's a horror story. This client pretty much lost this whole section of business, and that new competitor actually had over $500,000 in gross revenue in their first year, and they spent none of the investment on this. And then they had another, over $1 million in their second year. So they really were able to steal this just because they had a contract that was outdated, that didn't have these type of covenants in there. So when people ask me, why is this important? I wish they knew this story because I think it's very telling.